My lords, an argument was made that any kind of reading into the SMA would go against the core or the grain of the legislation, using the Gaidan phraseology, and therefore reading in persons cannot be permitted. My lords, I want to submit that the core of the SMA from the parliamentary debates is that it moved away from the sacramental nature of marriage to a contractual nature, and its core was freedom of choice in marriage. And my lords, the parliamentary debates, my lords, may just kindly see my submissions, rejoinder submissions, my lords. Parliamentary debates we have now obtained and they are extracted, which clearly show that the core of the SMA was free choice in marriage and it did not exclude any person. Even in 1954, of course, at that time it was a man, woman, but this was irrespective of faith and caste and based on constitutional principles. My lords may just see page 2 of my written rejoinder submissions. In page 2, I will just read out.
Yes, we've made the point.
One or two extracts where one of the...
we see the point. What is the next point?
My lords, I will just read out one extract on page 5, that where one of the members in the debate says that we are living under a constitution where certain principles are guaranteed to individuals, liberty of speech, liberty of association, which in my opinion includes the right of every person to choose his or her partner as she desires.
All right. What is the next point, therefore?
Yes. So my
the sequitur.
Yeah, my lords, is that the debates show that even the SMA was a marriage law for freedom of marriage and choice, and therefore, my lords, reading in as persons would in fact not go against it and would be required for a constitutional framework. And it was never meant to exclude anyone, my lords. And my lords, therefore, reading in, while other judgments have been relied upon, I go on to independent thought. My lords, in independent thought, the exception to rape, 375. In fact, an argument was made that would it be reading up and would the exception to rape for the marriage of a woman, wife aged 15 to extend it to 18, would it be seen as making a new offense? That's what the court asked. Can we make a new offense? And then the court said that we are not making a new offense, but if we don't read 15 as 18, we are in fact failing our constitution duty. And in fact, the court said what Justice Lokur and Justice Deepak Gupta said, that the court said that if we want to make a purposive interpretation, they did not term it reading in or reading up or reading down, but to give a purposive interpretation that protects the rights of the girl or minor girls under the constitution, because the age of marriage was 18, she would lose her right to choice in education and in life. There we have to step in. And in fact, the court said that the court would be failing in its duty if the legislature enacts a law which is violative of the fundamental rights of citizens, is arbitrary and discriminatory. The court would be failing in its duty if it does not either strike down the law or read the law in such a manner that it falls within the four corners of the Constitution. That's all we are asking, my lords, to read it in a way that persons are included, to cover it and make it constitutionally compliant. And my lords, finally, the last point is that, my lords, for trans persons, NALSA specifically guarantees the right to marry. There is a specific requirement that legal recognition is required for enjoying all civil rights by this community, the right to own property, the right to marry. When there is a right to marry, and my lords, when under the Special Marriage Act, transgender persons who have got their gender reassignment can come within man or woman. My lords, all we are saying is that give an interpretation that is purposive to make it all persons, my lords.
Thank you so much, Mr. Swami. Thank you so much.